Hi, Robert Wareham from the Law Center, continuing our series on House Bill 19-1177, dealing with extreme risk protection orders, otherwise known as the Red Flag Bill. In our prior two segments, we talk about who has standing to bring a petition for an extreme risk protection order, and we also talked about what the process was to get an extreme risk protection order. One of the things in the process is the court, within 1 day after the petition being filed, has to set a date within 14 days, at which time they will accept further evidence. Remember, the first hearing, which was held potentially even just by telephone with the petitioner and the court, was ex parte, meaning that the respondent, the person restrained by this extreme risk protection order, has no opportunity to be heard. There's been no cross-examination of the petitioner or any other witnesses. So now we're moving ahead to this hearing that's going to be held within 14 days, but remember, there is no limit on how short that amount of time could be. The judge could say, I want people back here in 3 or 4 days. There might be some who would view that as a positive because the respondent would be without firearms for a shorter period of time. At the same time, from the standpoint of a legal practitioner, it's very difficult to put together a case, gather evidence and witnesses in that shorter period of time. Okay? So if we're looking at when we're going to do extreme risk protection order hearings, here's what we're having to do with regard to the respondent. The court has to provide notice. This notice is provided by the protection order, the extreme risk protection order, being personally served on the respondent. The statute, as it's written, specifically authorizes the court to hold this hearing by telephone to accommodate disabilities or in extreme circumstances to protect the petitioner from potential harm. But that becomes problematic because frequently the credibility of a petitioner is at stake, and it's very difficult for a court to observe body language and things like that when someone is on the phone. So a copy of the notice of the hearing and the petition is served along with the extreme risk protection order, is served on the respondent by personal service, which means the documents are handed to them. The standard of proof that the court applies at the initial ex parte hearing is a very low standard of proof. It's what we call preponderance of the evidence, which means 51% essentially. More likely than not that the respondent poses a significant risk to himself or others. The standard of proof at the 14-day hearing is a little higher, and it requires the court finds by clear and convincing evidence based on evidence presented pursuant to subsection 3 of this section. So let's take a look at what is some of the evidence that the court is to consider. Well, first of all, it says the court may consider any relevant evidence. So the list I'm going through here is sort of consider these, but you're not limited to these, Mr. Judge or Ms. Judge. Okay, so a recent act or credible threat of violence by the respondent against self or others. Now that's similar language we use in just regular old protection orders. It has to be a credible threat. It can't just be sort of an anecdotal remark, but a credible threat of violence or, against respondent, by the respondent against himself or others. A pattern of acts or credible threats of violence by the respondent within the past year. Okay, a violation by the respondent of a civil protection order. So now we're seeing, maybe a little lesser things, because if you stop and think about it, a civil protection order could have been that you have no contact with someone and the violation was sending the person a text message. Does that necessarily rise to the level of warranting taking someone's firearms away from them? A previous or existing extreme risk protection order issued against the respondent. So in essence, what we have here is sort of a self-perpetuating thing where once you get an extreme risk protection order issued against you, the likelihood that you'll get an additional one in the future may be increased because a factor that a court is to consider is, has there been a prior extreme risk protection order? And if there was there a violation of that order? All right? A conviction of the respondent for a crime that included an underlying factual basis of domestic violence. So there they make a reference to a Title 18 section. And in Title 18, that's where we get back into that intimate partner type of relationship where anybody that you've been closely involved with, and remember, sexual intimacy is not a requirement of that. It could be someone that you've dated casually on and off for several months, could fit within the definition of an intimate partner. And therefore a basis for domestic violence. The respondent's ownership, access to, or intent to possess a firearm. So now what we've done, we've made the mere ownership and possession of a firearm potentially something from which a court could draw a negative inference. Well, you own a gun, so maybe that's a factor to consider. Next one is a credible threat of unlawful or reckless use of a firearm by the respondent. So again, we're back to a credible threat of I'm going to take my gun out and do something with it. The history of use, attempted use, or threatened use of unlawful physical force by the respondent. All right, so now we don't even have firearms involved. We have pushing, shoving, striking physically, but now we're taking away someone's firearms for some sort of an incident that had no nexus with ownership of a firearm. Any prior arrest, this is a really bothersome one. Any prior arrest of the respondent for a crime listed in Title 14, Article 4.13021. Well, I pulled that one up, and it is just amazing. This is a list that goes all the way through the alphabet, A through Z, and then double digits all the way up to MM. So we're talking about almost 35 crimes. And remember, the ERPO statute, the Extreme Risk Protection Order statute, does not require a conviction. This, to my knowledge, is the first time that a statute has ever said if you got arrested for one of these things, the mere fact that you got arrested can be used against you. I'm not going to hit on some of the obvious ones. Well, some of the obvious ones in 4.1302 are murder, manslaughter, things like that. But listen to these. Assault in the third degree. Assault in the third degree could be grabbing someone's arm, causing them mild pain. That's not exactly an aggravated crime. It's the lowest level of assault there is. Vehicular assault, menacing, invasion of privacy for sexual gratification. In other words, being a peeping Tom. What does being a peeping Tom have to do with whether or not someone should own firearms? Child abuse. Now, you might think, well, we don't want people who abuse child having firearms. Believe it or not, if you are arrested for driving under the influence and you have a child in your car, you will be charged with child abuse potentially, and now that's a factor in whether the court is going to issue an extreme risk protection order. Any crime identified by law enforcement as charges of domestic violence. An act identified by the DA as an act of domestic violence. A bias-motivated crime. What does that have to do with firearms? Careless driving resulting in death can be a factor in whether or not an ERPO issues. Failure to stop at the scene of an accident resulting in death. Any criminal attempt, any conspiracy, intimidating a witness, indecent exposure. I know people who've been charged with indecent exposure because they, had a few too many drinks and they urinated in public. Now that is a factor that the court is to consider. Another one of these is abuse of animals, cruelty to animals. So if you leave your dog in the car on a hot day and you get charged with animal cruelty, that is now a factor to be considered by the court when entering an extreme risk protection order. Back to the main list here, abuse of controlled substances or alcohol. All right, and then this is a really odd one. Whether the respondent is required to possess, carry, or use a firearm as a condition of the respondent's current employment. So what they're suggesting here is, we think you're crazy enough that we're going to go get an extreme risk protection order, Yet you may at the same time be employed as a law enforcement officer, a security guard, or something like that. Which is it? Are they crazy and shouldn't have firearms? Or are we going to look at it and the court's going to say, well, he's crazy, I'd normally issue an ERPO, but because they need it for their employment, we won't do it. It just seems like an odd inclusion in there, almost sort of an exception for people who would otherwise lose their firearms. So those are essentially the factors. The last factor, and this is a kicker here too, evidence of recent acquisition of a firearm or ammunition by the respondent. So in other words, if I happen to go out and buy a new firearm, and maybe my wife is angry at me for that, she can go down and file a petition, and the mere fact that I bought the firearm is a factor the court is to consider in whether or not to issue an extreme risk protection order. So that's basically what the court's going to look at the 14-day hearing. In our next segment, we'll talk about what standard the court will apply, and then what the court's options are at that 14-day hearing on the temporary extreme risk protection order.